was written from the respondents and then the APC. Yeah, that have been filed by Tinubu and the APC. Some of the points they have raised are strong. The fact that a point is strong does not necessarily mean that it will succeed in court. It is just that they are germane. They are not objections or issues that you can just dismiss by a wave of the hand. Some of them are just basically activated to distract the petitioners and also create some sort of credibility crisis for the election petition, even though I do not see how those objections can fly. For example, the issue regarding Obi's alleged belated membership of the Labour Party. I don't see how that is even a matter for them to bother is a second on. I don't see how that can be countenanced at the tribunal. I will want to see how the Court of Appeal will respond to them. But my assessment is that that is basically done to distract the petitioners. One, because the issue of membership of a political party, the Supreme Court has said repeatedly, it is internal affairs of the party, right? It is not the business of outsiders or non-party members to complain about it. And even where there should be a legitimate complaint arising from any provisions of the party constitution, INEC guidelines, the Electoral Act, or the Constitution, such complaints must be brought within the purview of a pre-election matter, which must be filed within 14 days. Again, that can only be done by an aspirant who participated in the primary that will be contested in and became the candidate of the Labour Party. It is not something that can be activated by outsiders or people who have no stake in the matter. So I see that as a distraction. In any event, the provision of the Electoral Act that they have cited does not support the argument, because it says that a party shall submit the list of its members to INEC 30 days before primaries or congresses. It does not say that after that time, the party can no longer admit new members, or that the new members will not be eligible to contest in the primary to become the candidate of the party. It does not foreclose that right. What the Constitution says is that one should be a member of the party and be sponsored by that party. And it is the party that determines sponsorship. So I don't see how this is the business. One, APC doesn't have the locus. Tinubu doesn't have the locus to argue on that. And even on the merit, for me, the argument is a non-starter, really. It is a non-starter because what is the issue? What is the complaint about? That is not a member of the Labour Party. Are you the one to complain about that? So I don't see how that is a problem. And political parties, even if we are to look at the merit of the argument, parties have the right to grant waiver to anybody to contest on their platform. You don't need to be a member of that party for any definite period. The party can grant waiver. So if the party says, this is our candidate, this is our member, and you said no, because your name is not in the register that was submitted 30 days before primary, you cannot be the candidate of the party. That is stretching the argument beyond what the law can, what is legally permissible. So that is about that. Okay. The other issue about not joining article, I think that is just not joining article in the UB petition, and they have also made the same argument against article that they did not join UB. I think those are just, I think that is another, interesting argument, but I don't see how that really matters, really, because INEC is the one that conducts election. And the areas where votes have been, where the petitioners have made complaints regarding the votes that were recorded, right? The law does not say that in a state, for example, I read where Tinubu is complaining that why it will be complaining about results in states that he did not win. The law does not say that the petitioner should concentrate on states that the man or the person candidate returned elected won. No. Any state where you believe that what you should have been due to you in terms of votes was not given to you, recorded for you, you have the right to challenge it. Otherwise, the implication will be that a petitioner has to join all the presidential candidates and political parties. You cannot make a special exception for article, and you don't make it for the AAC, you don't make it for the other political parties. Therefore, all parties, all the 18 parties, all the parties that had candidates must be made parties to an election petition. That will make nonsense of the entire process, because those parties also recorded votes. The law does not say that you should challenge votes from a state on percentage basis. I don't know if you get me.
Yeah.
So it is not a question of saying, oh, Article 1 in this state, why am I being challenged in those states? No, that is not the basis. That is not the basis. And recall that in our previous engagement, I took time to explain the disparity in law between lawful votes and majority of lawful votes. One can have a majority of votes, but those votes may not necessarily be lawful votes. So these are the issues. I see that those objections on those two grounds as just very distracting. I don't see how those ones are going to fly. The one that is a bit strong is the one regarding the allegation of drugs or Tinubu's indictment in the US. Again, that is going to depend on the attitude of our courts, how the court is going to perceive the issue.